Good morning, everyone. Today is Tuesday, March 31st. It's 10 a.m. Pacific Standard Time. Today's webinar is about the top 10 questions that time and time again we get asked at Family Law Matters and are circulating the internet. We're joined by the Family Law Legal Panel. We're going to give you as much direction as we possibly can. We do want you to keep in mind that these are some uncharted territory. And we're going to do the best that we can to guide you through it. Let's start with the introduction. Colleen, you're first on my screen.
Good morning, everyone. My name is Colleen Robinson. I'm an attorney here at Family Law Matters. I've been an attorney, hard to believe, 10 years now, whole decade. I've been practicing throughout Southern California, mostly in San Diego and Riverside counties, exclusively in family law.
Thank you, Colleen. Gina.
Hi, I'm Gina Famularo, and I'm one of the partners at Family Law Matters. I've been an attorney for 23 years. I spent my entire career practicing family law. I practiced for 9 years in Orange County and the balance of my career in Riverside County.
Thank you, Gina. Christy.
Morning, everyone. I hope everyone is safe and healthy. I am Christy Bergamo. I am a family law attorney, a senior family law attorney here at Family Law Matters. I've been practicing 17 years, and I'm also certified to represent children in court. And so I get appointed by judges to do that. And I just want to welcome everybody to our webinar.
Thank you, Christy. And I am Bishoy Shahada. I'm also an attorney, managing partner at Family Law Matters. I've been practicing for a little over 2 years. Only family law is all I know. And with that said, let's get started. Gina, I'm going to give you the first question that we keep getting, which is do the governor's orders of Safer-At-Home and Shelter-in-Place due to COVID-19, do they supersede current custody orders?
That is a great question, Bishoy, and the truth is no one really knows. Originally, the shelter-in-place orders were expected to be for 2 weeks, and I think that everybody thought that the 2 weeks was a pause for the entire state. It looks like now they're going to be extended at least until the end of April. We don't know how long the shelter in place is going to be extended. So what we're telling our clients is take it on a case-by-case basis. You need to contact your attorney and you need to get specific instructions regarding your specific case.
So let's dig into that a little bit more. If I decide, or not decide, if I am taking the governor's order and following the shelter in place, but the other side is not, and there are current custody orders, do I send the child?
Well, that's a very simple question with a very complicated answer. What we're telling people is if you have safety concerns, either for people in your household, people in the other household, or for your child because of some underlying condition, or perhaps someone is a first responder, such as a doctor or police officer, number one, you communicate with the other side. Number two, you try to get an agreement in writing that will protect both households and the child. Number three, if you do take a pause in visitation, you always offer makeup time. And number four, if you cannot reach an agreement with the other side in writing, you must consult counsel.
Thank you, Gina. And then Colleen, with the courts, I know the courts are closed, but people are uncertain as to when they will reopen. Do we know as of now when the courts plan on reopening?
Well, right now, as far as we know, the courts are, some courts are, as of right now, resuming or saying they're resuming as of Friday, and then on April 3rd, and then also April 6th. However, there is, on tomorrow afternoon, Wednesday, the Riverside Court is doing a teleconference updating us as to what's going on amidst the COVID-19 situation. So I've been telling clients that have upcoming hearing dates. As of right now, we're planning on going forward on Monday until we're told otherwise. But if we get any other information, we'll be updating our clients. But that's the information we have so far.
So if I understand, go ahead, Gina.
Can I add to that just a bit?
Yes.
There was an emergency hearing by the Judicial Council on Saturday, which I did monitor. And what they're indicating is that they're asking the governor to make an order to accommodate litigants electronically. So what I think we're all anticipating is some form of electronic appearances, I guess you would call it, electronic litigation in the near future.
Thank you, Gina. And Colleen, back to your point. So just to clarify, if I have a hearing that is scheduled for April 6th or beyond, anytime in April, is that still going forward?
As far as we know, yes. So, and I've got 3 hearings on Monday that I'm preparing for because we haven't received any other information indicating that those hearings have been continued or they're going to be continued. We'll find out that information tomorrow, and we'll be updating our clients with whatever the court has provided to us.
Okay, and if I don't have a court hearing, but I have a legal emergency before the court's open, what do I do?
Well, one, I think you need to consult with an attorney. Call our office and let's talk about what that legal emergency is. Right now, we're defining, or the definition of a legal emergency is domestic violence, child abduction, or physical abuse. So we need to talk because we need to get all the facts to determine what you think your emergency is, because the courts are still open for those emergencies. So please call us. Let's see what we can do to help you out. The courts aren't completely closed, as we've indicated, in terms of ex partes and restraining orders. So please call us.
And if parties want to file, but for some reason are unable to secure representation, can they go to the court to file? Is the self-help center open?
That's a really good question. And from our experience, the courthouse is pretty much closed to the public. Everything's being submitted electronically. The self-help centers are closed. So that's where it's really imperative, I think, at this time to have an attorney to help you navigate these uncertain, uncharted waters that allow you to still get into court, because we still can file paperwork on your behalf, secure your court date, get your court date in the future, and start helping you right now in this uncertain situation. So there's still avenues that are open, and we know how to navigate those avenues. So please give us a call.
Thank you, Colleen. And Christy, I'm going to shift the topic a little bit to you, just to Colleen's point that we can still file. Now, let's talk about the support aspect of that. If I was laid off due to the financial hardships that companies are experiencing nowadays due to COVID-19, and I can't afford to pay a court-ordered support, what do I do?
Well, first, I want to add something to what Colleen said.
Please.
And it's important to consult an attorney and have them navigate you through this, because we know how to communicate with the courts.
Mm-hmm.
I think that's a huge point that needs to be made. And because the issues are so complex, I think you need that experience to be able to communicate what exactly is going on in your particular instance and be able to address those with the court appropriately and, well, because I think there's not going to be a lot of room. You understand the courts are going to be completely impacted, and you want to make sure that your request for order, whatever you file, is addressed and addressed promptly based on paperwork that is of a caliber that can make that evident of what your issues are to the court. Mm-hmm. That was my comment on that. B, to answer your question, if someone is experiencing, which a lot of people are, temporary layoffs, permanent layoffs, a reduction in commission or a reduction in pay, all of those issues are really prevalent right now. And what you need to do is you need to file. You need to file something to now understand it may take a while to get your filing back from the court, but you need to file, because what I don't think people understand is there is a large difference between when you file something and then when your hearing is. And people think that they can just file something with the court and the court's going to order it on that day. It doesn't work that way. So you need to file. That's why you need to consult your attorney. You need to tell us the specific issues, financial issues in your case, and then we need to file something to preserve your retroactivity. Now, this may be just temporary. So certainly, if it is, then it's a much easier issue, I believe. But it may be something long term. But again, you need to file. You need to preserve your place in line.
So let's dissect that a little bit more, because there's a difference between someone who's completely laid off and doesn't have an income and is filing for unemployment. And there's a difference between someone who's experiencing a temporary cut or a temporary reduction. And then there's a difference between somebody who's solely on commission and is completely affected by it. So let's talk about each of those separately. So I know you addressed if they've been laid off. Now let's talk about someone who's received a temporary cut in pay. Can they still file for a modification of support?
Absolutely, and I think you have to. I think in all of those instances, the filing has to happen, because I mean, we've been talking on these webinars about communication. So let's back up. Let's start there. We communicate with the other side what our financial difficulty is. Number one, maybe we can get an agreement in writing, but it's got to be in writing. It's got to be a stipulation that's filed with the court, and we can help you prepare those stipulations. But if that doesn't happen, and I don't foresee a lot of people who receive support saying, sure, you know, I'll just take nothing from you right now. I think it's going to be a contentious issue, unfortunately. And so if you can't get that stipulation in writing and filed with the court, then in all of those instances, you've got to file something to preserve your request to modify.
And if I take if my pay is temporarily cut, if I send a text to the other side and say, hey, I can't make the full payment, can I pay you something less? And the other side says, sure, that's fine. Is that sufficient? I
would say no. I would say no.
Can you elaborate?
Yes, because I'm an attorney who litigates often. I guess I'll put it that way. So, and I have had many trials regarding whether or not something like that constitutes an agreement to modify the support. So I have had judges come down one way and say, yes, it's sufficient. And I've had other judges come down the other way and say, no, that's not enough. You didn't file a written stipulation. And I think it goes to the language of the stipulation as well. What period of time? I mean, you have to be very specific about what you're agreeing to in terms of a waiver of child or spousal support right now, a reduction of child and spousal support right now, what time period it encompasses. So no, my rule of thumb is no, because like I said, I've won and lost that issue. So I would never want to put any of my clients in a position to say, yes, that's good enough. I mean, I think we've got the time to focus on, you know, navigating through this. We might as well do it right. So no, I would say no, that's not good enough.
And can support be temporarily reduced and go back up to where it was when the pay goes back to normal?
Absolutely. And again, those I think are the stipulations that we can certainly enter into, is that we're all mindful of what's going on. Hopefully we're all being reasonable. And if this is just a temporary issue, then it's not going to encompass that much of time. So I think it would be easy to try and get a stipulation in that regard. Now, if someone has been permanently terminated and does not have any job lined up, I mean, we don't even know what's going to happen when the workforce opens again, if you will. Like, what's that going to look like? What jobs are going to now be necessary that weren't? Who's going to be hired back? Who's going to be hired in other fields? We we don't know. So again, the most important thing is if you can't get a stipulation that's in writing that we file with the court, then you need to file a request to modify immediately. You can't wait. If you wait, because what, again, people don't understand is, oh, the court's going to understand that, you know, I lost my job, but I didn't file anything. I'll tell everybody statutorily, that means the rules are that the court can only go back to when you filed that request to modify. So you have to file it. If you don't, the courts know, the court's not going to understand. They're not, because they can't. They're bound by the statute, and the statute says that the retroactivity is when you file the relief, for the relief.
Thank you, Christy. And then I have one more question for you on that same topic, and it's for someone who is working full-time and is still during this time working, or during the shelter-in-place orders is still working full-time, but they're only commission-based. So obviously with everything closing around and people staying at home, their commissions are affected by that and are greatly reduced. How does that differ?
It really depends on your current order, okay? So some orders are based on an average of what your pay is. So say for instance, consistently in the past, you made approximately $2,000 a month in commissions. So what some orders say is that they just put in an average of your commission plus your base pay. So you pay something consistent each month, like $500 per month. That is very different than orders that have what's called an Osler-Smith. Those are you pay out on your base salary, and usually it's when commissions are more varied, they go up and down. So you don't want to be bound to something on an average because you don't know if you're going to get it. They're a little bit more unforeseeable. So basically those orders read that if you earn the commission, you pay off a chart that has percentages. In that instance, I think the person who's not making the commission and they're just getting their base salary don't need to modify those orders because their commissions are at zero. So the Osler-Smith is not applying or does not apply. In the other instance, when your orders read that you're paying on an average, then absolutely you need to modify those orders or file for the modification immediately, because obviously that average of $2,000 isn't there anymore. So that's a significant decrease.
So bottom line, if I understand you correctly, is because this is a sophisticated distinction, bottom line is an attorney needs to review your order and determine whether you should file or not. Fair enough?
Oh, absolutely. I have tons of clients who don't know what their orders say at all. You know, and that's perfectly normal. I mean, you know, a lot of people read legalese and want to, you know, roll their eyes. So absolutely, it's incumbent on us to review your orders and be able to tell you which category you fall in that particular situation.
Thank you, Christy. Gina, I'm going to switch gears and talk about property orders. So your order to sell the house, but the party living in the home at currently is not cooperating due to the shelter-in-place orders and COVID-19 and the fears. What do I do as the client?
Well, you need to retain counsel immediately because the courts are right now not closed. You probably are going to need to get some judicial relief, and you need to get in line as soon as possible so that you can get the relief you need. What you don't want to do is nothing. An attorney can perhaps write a letter. An attorney can perhaps make a phone call. An attorney maybe be able to call the realtor or the escrow company or to intervene in some manner. But if that doesn't work, you need judicial intervention, and it's imperative that you do it now. And waiting may prejudice you because who knows, maybe the house is going, maybe the market's going to drop, maybe this is going to go on for a couple more months. We just don't know. So we need to act now.
And when you say the courts are not closed, you mean they're not closed in the sense that they're still processing paperwork and reserving court dates, but they're not open to the public, true?
It sounds like I misspoke, and yes, that is an accurate statement.
Perfect. Thank you, Gina. And then what about if the two parties are separated, and the party that is living in the home is not making the mortgage payments right now? What relief and what do I do?
Sure. So when people are going through a divorce, both parties have a legal obligation to preserve the marital asset. They cannot allow some asset to go into foreclosure or to lose value. And if one party's not paying the house payment, then there's a number of options, a number of actions that can be taken. Certainly you need to consult with an attorney, because some of the actions should not be taken without legal advice. For instance, maybe the spouse not living in the house is going to make the house payment. That's not something we would advise without looking at your particular situation. Certainly you need to file for judicial relief if an attorney cannot intervene and put a Band-Aid on the situation. Additionally, right now, there is new laws that have been put into place by the Senate and Congress, which allow for relief. Governor Newsom has put a moratorium on foreclosures right now. Banks are deferring payments on the mortgage. Certainly, you're going to need to call your bank. You're going to need to see if the bank will give you some sort of financial relief, and then you need to call your attorney, and you need to see what your attorney can do to help you. We have a whole slew of tools in our toolbox that can help you, only one of which is filing for judicial relief.
And it's my understanding that, and again, this is probably not our area, but I want to let the viewers know that it's my understanding that depending on where your mortgage is and what bank it's through, some banks will offer a deferral period of 30 days, and it goes up to 90 days. Is that your understanding?
Yes, and even before this whole COVID-19 crisis has occurred, I've had clients that have been able to call the banks, explain the situation, that they're going through a divorce, that they're asking that the house be sold, and it had the banks put mortgage payments at the end of the mortgage to preserve the asset, because the mortgage company doesn't want to file a foreclosure any more than you want them to. It's incredibly expensive for mortgage companies to do that. So they're usually wanting to work with people who are experiencing financial hardship.
Thank you, Gina. And then Colleen, I'm going to come back to you with a very generic question, but we still keep getting it, which is, why should I hire an attorney now when the courts are closed?
Well, for one, the courts aren't completely closed. And right now is the time, given all the uncertainty, that it's nice to have someone on your side that's going to work for you. And that's what we're doing. We're trying to come up with creative solutions and resolutions to the issues that are occurring right now for our clients. Additionally, as Christy said, we need to get in line too. If you're seeking certain remedies that require judicial intervention, you need to get your place in line now with the court system. And as what I was referring to with Chrissy saying, is that you need to know how to speak the language as well, because the courts are reviewing documents, are reviewing hundreds of declarations, and we know how to present declarations and giving the court what it's looking for in order to make the orders you're asking for. So let us help you do that. And with what we're anticipating with the courts being impacted after all this is over, and once it's completely open, it's even more important to get that information to what the judge is looking for, because we don't know how busy that they're going to be. So I think right now is still a good time to act. We can intervene on your behalf. We can talk to opposing party. We can talk to opposing counsel. And as Gina was referencing, trying to get stipulations, and Christy too, getting stipulations. And if all of that fails or it doesn't work, then we're going to file the motion and preserve your place in court once the courts open up and resume business as normal. Or even doing the electronic hearings that we are anticipating maybe happening. So let us help you navigate the times now, get your place in court, and with how we prepare our declarations and getting that information that the court needs to make those orders.
So is it fair to say that the legal the court system itself is complex. Navigating the court system itself is complex.
It is complex. And even if you ask me, even talking to clients who first go to the self-help center, while those are very helpful, they're not attorneys. They can't tell you, they can't give you legal advice. So they can show you the forms. Sometimes those are all the forms, sometimes they're not. And then just go figure it out. And that can be even more frustrating and get you lost in the weeds even more so. So I still think that it's very important for you to hire an attorney.
But that's even worse now because the self-help is closed.
Right, that's exactly why you should call us.
Okay, so again, it's not a matter of I don't need you right now, I'll deal with it down the road. It actually is more harmful to the case to wait because you're not reserving your spot in line and you don't know at what point is the court going to hear your case. Is that fair to say?
That's a very good point, absolutely. And you don't want to run into a situation where you go to court and then it gets continued because you failed to provide the right documentation to the court, or you didn't present or present it right to the court or file the right documents, and then it gets further on, it gets bumped out even longer. So the courthouse is a very complicated system. It's not easy to navigate by yourself. We're there when they were open. We're there every day, and we're dealing with these judicial officers every day. We know the information that they're seeking. We know how to speak their language and present the cases and the facts in a way that they really digest the information and then try to get the best results for our clients.
Thank you, Colleen. Do you have any closing comments for our participants?
Just hang in there, everybody. I know that it's a lot of information that we're getting every single day, and it can be very nerve-wracking, especially if you're watching the news every single day. We don't know what's going on, but I know that as our team here with the attorneys and with the paralegals, we're trying to do whatever we can to help the situation, de-escalate your anxiety and your stress, whatever we can do. So please reach out to us. We're here to help you. And we're here, so let us help you.
Thank you for that, Colleen. Christy, do you have anything to add to that? Any closing remarks?
I think she did a pretty good job there, and I would just reiterate those sentiments. I think, you know, we're all in this together. It's very uncertain times, so our information to you is based on what we have. So it might change, it's subject to change, but I think one constant is that if you have issues that cannot be resolved by way of an agreement, then you need to file an action. And I can't stress it enough, and especially, you know, with the support issues, I just, there's no way around it. And Colleen brought up a very good point. I can't tell you how many times I'm in court and I see a self-represented litigant and the judge kicks out their request to modify based on they lost their job out for 3 months because the paperwork wasn't drafted correctly. The income and expense declaration didn't have pay stubs attached. Those kinds of issues. And I anticipate when the courts open, the impactedness of the courts is going to be extreme. I mean, we go to court every day. There's usually 20. I've been to court where there's 30 matters on calendar, and that gives the court basically maybe 10 minutes to go through each case. And now that all of these cases have been continued out, I don't even know what that's going to look like. I don't know if the court's going to extend their hours, possibly. I don't know, but it's all very uncertain in that regard. So the best thing we can do right now is prepare now for what's going to transpire later. You know, we need to be proactive. And like I said, I just, you know, my heart goes out to everyone right now, including myself. We're all in such a uncharted territory that, you know, we all just need to navigate through this together and stay healthy.
Thank you, Christy. Rita, any closing remarks?
Sure. If you're experiencing legal problems, hire us because we know how to speak the language of the court and we know how to navigate the system.
Very short, sweet, straight to the point.
Like it.
Okay, so just a couple of final points. I do want to remind everyone that tomorrow, it looks like April 1st, the court is holding a session with updates. It's between 10 a.m. and 11 a.m. So it's going to be during our webinar, which means that we may have to delay our webinar just so we can have the updated information for you guys. So just be patient and we'll get you as much information as we can. Number two, please remember that these sessions are recorded and are posted on our social media websites, our YouTube channel, and our Facebook page. They're also going to go on the website at some point. I just don't have a deadline for that yet. Number three, please continue to send us your questions. That's what we're here for. We're taking the time out of our day to continue to give you updates, continue to give you guidance, and continue to walk you through the process. Time and time again, we've said it, these are uncharted territories. These are unknown times, but we're all going to get through it. So please remember to stay safe, stay healthy, and continue doing the best that you can, and we'll get through this. Other than that, I want to thank everybody. Thank the legal panel. Thank you guys for taking the time out of your day. Thank you for our participants for taking the time out of your day to sit in with us for these 30 to 40 minutes and give you some updates. Tomorrow's webinar will be on the court's updates. So as soon as we have those updates for you, we'll make sure that we incorporate those in tomorrow's webinar. So stay tuned. Thank you guys. God bless.
God bless.
Bye.